Okay, so this, by the way, is a heavily photoshopped image of a grainy picture that I got off the internet of, I think, one of the original sodomy laws in the Commonwealth, the colony of Massachusetts. So, okay. On June 26, 2003, the Supreme Court decided Lawrence v. Texas 5-3 in favor of the petitioners, John Geddes Lawrence and Tyrone Garner, who were arrested and prosecuted after, in the words of the court, Texas police, responding to a false report of a weapons disturbance at a private residence, found Lawrence and Garner engaged in anal sexual intercourse in Lawrence's apartment. And one thing we could possibly discuss in the Q&A is that this was entirely a fiction. None of this was true. But it was kind of maintained throughout the entire process of the trial for a variety of different, some productive reasons. So Lawrence reversed a lower court ruling upholding the so-called Texas Homosexual Conduct Law, a law that criminalized sodomy, which Texas defined as deviant sexual intercourse specifically between two persons of the same sex. And the law was primarily used to prosecute gay men who had anal sex with each other. The court also overruled its 1986 decision in Bowers v. Hardwick. In that case, the court had refused to find Georgia Statute 1662, which both defined and criminalized sodomy and aggravated sodomy, unconstitutional. Writing for the Lawrence majority, Justice Anthony M. Kennedy argued that the Texas statute, along with Statute 1662, violated Lawrence and Garner's rights under the Due Process Clause of the 14th Amendment. There are two common stories about Kennedy's opinion for the court in Lawrence v. Texas. Well, there's probably more, but I'm going to highlight two. Both appear in various forms in the popular gay and lesbian and other progressive press organs, legal scholarship, queer legal theory, and a variety of other places. I call these two stories the Unlikely Watershed and the Critical Queer story of Lawrence v. Texas. In the Unlikely Watershed story, Kennedy's opinion offers the country a long overdue and welcome repudiation of Bowers v. Hardwick. The Justice's declaration of the unconstitutionality of anti-sodomy laws is a marker, in the words of Kirk Davis Swinehart, of the gay and lesbian civil rights movement's newly, quote, acquired powerful aura of inevitability. Swinehart goes on to say that this new aura was, quote, inconceivable as few as 10 years ago, when sodomy laws remained in effect in 13 states. In the critical queer narrative, Kennedy's opinion should be acknowledged as an important judicial attempt to decriminalize consensual sex between men, but not celebrated as removing a fundamental barrier to sexual and relational freedoms. Queer and colored legal scholars in particular have recently pointed to Kennedy's invocation of a particular genealogy of constitutional precedent within which privacy, marriage, and procreation are set up as the core issues in terms of which all constitutional questions regarding intimacy, sex, and relationships should be decided. So here is the passage from Lawrence that I think most lends itself to this interpretation. It is probably the most or perhaps only well-known piece of prose from Kennedy's opinion, to the extent that any piece of prose from almost any constitutional opinion can be well-known. The grammar of this paragraph suggests that legitimate queer subjects of the post-Lawrence Constitution are only lesbian or gay. They are not married, not monogamous, not private, not citizen, not productive, and not white. A more perhaps optimistic reading of this passage, however, might situate it in the context of a common doctrinal test. That is an argument test used by judges to weigh the benefits of a governmental policy against the degree to which it might violate constitutional prescriptions. A common doctrinal test that appears to provide the framework for Kennedy's 14th Amendment arguments. Kennedy's series of does nots here come at the beginning of the third to last paragraph of his opinion, which ends with the justice's ultimate legal holding that, quote, the Texas statute furthers no legitimate state interest which can justify its intrusion into the personal and private life of the individual. Kennedy doesn't say so explicitly, but this sentence appears to be his application of what is called the rational basis test. Rational basis is the lowest level on a testing scale that tops out with strict scrutiny, which requires that a policy be, quote, narrowly tailored to a compelling government interest in order to justify its reliance on constitutionally suspect language or principles. So there's really no such thing as something that's absolutely unconstitutional. Anything can be constitutional given a good enough reason. It is supposed to be very difficult for a statute to pass the strict scrutiny test. Rational basis, on the other hand, only requires that the policy be rationally related to a legitimate government interest, which is supposed to be a very easy test to pass. And at this point, you should also, if you didn't already know, have an idea of just how enervating it is to study constitutional law. Okay, so a justice's decision about what level of scrutiny to apply has a substantial impact, obviously, on what their ultimate legal finding will be. I mean, if you give something an easy test, it's probably going to pass the test. Kennedy's apparent application here of the rational basis test could be read as a lack of recognition of the severity of the Texas homosexual conduct statute. That is, if the law has no great impact, there is less need to hold it to strict scrutiny. The effect, however, is that rational basis allows Kennedy to suggest that the Texas statute, and by association, Georgia's 1662, is so far beyond the pale of any legitimate government policy that it can't even pass the easiest test. A suggestion, incidentally, that particularly rankles Justice Antonin Scalia. So that was Scalia being angry. Okay. So Scalia argued, I think, not without some cause, that it should be conceivable to find some rational basis to support, kind of some kind of law like this. And we'll actually be discussing, hopefully, what some of those might be. So here's an example of what may be called Anthony Kennedy's judicial tolerance. The does not passage, to return to it, is Kennedy's dismissal of a variety of possible legitimate government interests that a law like the Texas homosexual conduct statute might have. Lawrence is full of tolerance. The opinion consists of awkward analogy after awkward analogy between what Kennedy presumes must be the loving relationship between Lawrence and Garner, and they weren't even having sex when they were arrested, and heterosexual family forms. And it is possible to read his opinion as a heteronormative demarcation of legitimate constitutional boundaries of queer sexual and relational identity only and always already within the terms of marriage and what Kennedy calls kind of beautiful, loving relationships between two people. The petitioners in Lawrence were successfully presented to the justice as a particular kind of gay people that he could tolerate. And so he extended to them the sovereign protection of the U.S. Constitution. But Kennedy's tolerance has some radical potential. What Janet Haley, writing about his 1996 opinion for the court in Romer v. Evans, calls the nominalist politics of Kennedy's 14th Amendment jurisprudence. In Romer, Kennedy held that Colorado's Amendment 2, what might be called the gay people don't have rights in Colorado amendment, seems, quote, inexplicable by anything but animus toward the class it affects. It lacks a rational relationship to legitimate state interests, and thus must be found in violation of the Equal Protection Clause. So Romer, also Kennedy, applies this rational basis test. Normally in situations where the state enacts policy that treats persons differently under the law because of a suspect classification, like the homosexual, lesbian, and bisexual identity singled out in Amendment 2, the court employs strict scrutiny. In Romer, Kennedy's surprising application instead of the much easier rational basis test relieved the court of any obligation to celebrate, define, or describe as legitimate the classifications held to be suspect. Similarly, in Lawrence, the justice implicitly and explicitly defines legitimate gay identity and relation. But the rational basis framework of his opinion means that such definitions would not be required for future cases to be decided in a similar manner. The 14th Amendment of Romer and Lawrence is radically open to both subject-less and self-defining subjectivity, a trend continued in part with Kennedy's recent opinion for the court in United States v. Windsor. And you can see here again the rational basis test. So in Windsor, Kennedy, for a variety of reasons, does not need to talk about why marriage is awesome or about why gay identity is inextricably connected with marriage. It's simply enough that the state of New York allowed gay people to marry, and there's no reason other than animus for the federal government to disallow that allowance. So this is kind of, Haley's argument is that this is a nominalist, or you might say anti-essentialist, or radically open version of kind of queer subjectivity or identity before the law that's carried out throughout the sum total of Kennedy's 14th Amendment jurisprudence about sexuality. So, where am I? Here we go. But what I want to focus on today, finally, is another component of Kennedy's judicial tolerance. What I think is a kind of implicit constitutive outside to the justice's ongoing development of a certain kind of queer 14th Amendment. Much has been made about the question of whether the does not passage, again our friend, is a deliberate attempt by the justice to prevent Lawrence from being used as precedent to force federal or state recognition of same-sex marriage as a requirement under the Due Process Clause. So this, it does not involve whether the government must give formal recognition to any relationship that homosexual persons seek to enter, is often the most discussed kind of component of Lawrence v. Texas, because the question is, does this mean that you can't use the decision to support same-sex marriage? Marriage, however, is not the major focus of this passage. The first three does nots all describe legitimate government interests in anti-sodomy law. So this is a case that strikes down an anti-sodomy law, but specifies that this particular anti-sodomy law has no legitimate interests that other anti-sodomy laws could conceivably have. Other anti-sodomy laws could be directed at action against minors. They could be directed against rape and things like rape. They could be directed against public conduct or prosecution. Same thing. Okay. So remember Swinehart's powerful aura of inevitability. An aura inconceivable as few as 10 years before Lawrence, when sodomy laws remained in effect in 13 states. The problem with this statement, one that reflects common perception, is that actually the Texas and Georgia sodomy laws ruled unconstitutional by Kennedy's 2003 court order are still on the books in 2014, as are similar laws in Massachusetts, 15 other states, and even after the repeal of Don't Ask, Don't Tell, the United States Uniform Code of Military Justice. In Awful Acts and the Trouble with Normal, Erica R. Minders describes a historical connection between the criminalization of sex offense and the criminalization of queerness. Prior to Kennedy's ruling at Lawrence v. Texas, Minders argues sodomy was, quote, still a crime in many states. Accordingly, sex offender registries, or SORs, were originally established primarily as legal mechanisms of anti-quote male homosexual surveillance. But sodomy, post-Lawrence, is still a crime in many states. The effect of Kennedy's ruling is thus less important than the arguments through which he frames his legal holdings. So we often think of legal opinions in terms of the total ruling. I think I'm a rhetorician, so the way in which the argument frames operate actually have bigger effects, more significant effect on lives and kind of people's ability to operate as citizens or in other ways in the United States. The Lawrence opinion did not eliminate sodomy laws. Rather, it continued what was already an ongoing process of state and federal redefinition of sodomy laws as tools for the surveillance and punishment of sex offenders, as opposed to both gay and heterosexual people who engage in legitimate sex activity. Shortly after Lawrence v. Texas, as many of us here know very well, Massachusetts became the first state to ban any exclusion of gay and lesbian couples from civil marriage via the Supreme Judicial Court Chief Justice Margaret Marshall's 2003 opinion in Goodridge versus Department of Public Health. Shortly before Lawrence v. Texas, the Massachusetts Supreme Judicial Court dismissed GLAAD's, Gay and Lesbian Advocates and Defenders, 2002 challenge to Massachusetts General Law Chapter 272, Section 34, which defines and criminalizes sodomy as the, quote, abominable and detestable crime against nature, and Section 35, which defines and criminalizes sodomy as, quote, any unnatural and lascivious act with another person. So the dismissal was for lack of standing. In other words, GLAAD had no ability to show that it was a plaintiff or represented any other plaintiffs who had actually been harmed by this sodomy law. As part of the explanation for the court's dismissal, then Justice and now Chief Justice Ireland, as Ellen Ann Anderson puts it, quote, clarified that the state's two sodomy laws could not be applied to private consensual acts, end quote. So basically it was like, don't worry, we're not going to use these against you people. Instead, Sections 34 and 35 are supposedly, in reality, applied not only to acts of sex in public, lascivious, but also more often to persons accused of crimes now described in terms of sex offense. The striking thing about Ireland's dismissal and Ireland's assurance to GLAAD that none of their legitimate constituents would ever be a target of these statutes is that Massachusetts also has Section 35A, which specifies specific punishments for, quote, whoever commits any unnatural and lascivious act with a child under the age of 16, end quote. Even though Massachusetts has an independent legal mechanism for the criminalization and punishment of sexual abuse of children, the Supreme Judicial Court used the need for just such a mechanism, which it already has, as partial justification for refusing a suit against the sections that criminalize sodomy in just the broadest possible terms.
Just as Ireland's 2002 promise that the state's sodomy laws will only be used against those persons who fall outside the limited range of both identity and conduct that Kennedy would declare a few months later to be constitutionally protected, is precisely one thing that prevents an effective legal challenge against the ever-present possibility of that promise being broken by one of the myriad agents of Massachusetts law. In Massachusetts, the legalization of gay and lesbian marriage occurred, I think, in the context of the implicit conflation and reconflation of queer sex with all forms of criminal sex offense, a conflation that continues to enable and be a component part of the nearly unchallenged status quo of the criminalization of queerness as an important part of U.S. mass incarceration. Minors explains that, quote, as the use of registries, or SORs, to track and harass known homosexuals waned, in the 1980s, sexual offender registries found a new target in child predators, end quote. But make no mistake, the sodomy laws on the books in jurisdictions including Texas, Georgia, and the U.S. military, the latter is a particularly egregious example, continue to provide a productive cover for police and prosecutorial harassment of those LGBT and queer people who are, because of class, race, gender status, and other identity categories and subjectivities, most vulnerable to prosecution, police harassment, incarceration, and violence post-incarceration. Given the fact that SORs themselves disproportionately impact poor people and others already under surveillance and racially targeted by the state, and given that these laws underwrite other mechanisms of unjust incarceration, including indefinite civil commitment without adequate due process of prisoners who have already served out their criminal sentences, Minors asks, why the relative silence surrounding the recent expansion of SORs from anti-prison activists, feminists, and queers? Minors' answer is that, quote, historically, inclusion of marginalized people is purchased through the demonization of those of lesser value, and child molesters are an easy mark, end quote. Another version of this answer might be that it is an extremely difficult decision for an anti-incarceration activist to ally themselves with the group of people incarcerated who are the least popular, right, have the kind of least amount of public popularity, the least amount of political support in the United States. It's an automatic political win for a politician to advocate harsher punishments for sex offenders or child molesters. I would also add that Lawrence did not eliminate the sodomy laws designed to criminalize what we now call queer sex. Rather, it had the effect of shifting police and prosecutorial use of those laws to be more often a means of, now often permanently, incarcerating persons accused of the sexual abuse of children. Post-Lawrence, the criminalization of queerness continues as a mechanism of incarceration of persons implicitly marked as queer because of their sexual criminality. Conversely, the specter of the child molester is used as an affirmative justification, consistent with the argumentative framework of Kennedy's Lawrence opinion, for maintaining the criminalization of a constantly shifting terrain of illegitimate queerness via anti-sodomy statutes. So that as much as the state would like to claim child molesters and accused child molesters are absolutely not the only people who continue to be affected by sodomy laws, but they serve as the kind of unassailable justification for those effects. So I want to speak to this a little bit in terms of this question of window dressing and kind of progress, because I think that this example is really important to this question of what does it mean for victory. And one way to kind of describe the argument I think I'm making here in Minor's argument is that the legalization of marriage, kind of the drive to the legalization of marriage, if the converse of that is sort of the increased sophistication of particular forms of incarceration, then you could say that one argument you could make is that the drive for the legalization of marriage is affirmatively a bad thing that should be rejected by queer activists. Another thing you could say, though, is that the drive for the legalization of marriage has particular kinds of effects. And one kind of effect it has is in the way in which judicial rhetoric, kind of judicial speech, frames marriage legalization in a way that has these kind of other converse effects. And this places a demand, and this is, I think, Minor's demand, for solidarity among liberal marriage advocates and anti-incarceration advocates, a solidarity that frankly almost never exists. So I want to end with a small discussion of another Supreme Court case called Smith v. Doe. Actually, I'm not going to go there yet. Okay, so in Smith v. Doe, had to do with Article 1, Section 9 of the Constitution's ex post facto clause, which basically means You can't be punished retroactively for a crime that you were already punished for. So the plaintiff respondents in Smith v. Doe were convicted previously of sex crimes in Alaska, and then after their conviction and after their sentence, Alaska passed one of these highly restrictive sexual offender registry laws. And so they challenged their retroactive requirement to be registered and do various other things as a violation of the ex post facto clause and also the Eighth Amendment prohibition against cruel and unusual and specifically excessive punishment. So the court didn't agree with any of their arguments. And Kennedy actually wrote the majority decision in the same year that he wrote Lawrence v. Texas. And so the argument was, as Kennedy found, that this registry law was not a punitive law, but a civil law. It had to do with public health. It was not about punishment. And so therefore was not a violation of the ex post facto clause and couldn't be cruel, unusual, or excessive punishment because it wasn't punishment at all. Oh, it's good. Okay, thank you. This is similar actually in some ways to Lawrence v. Texas. So Lawrence v. Texas was about substantive due process. That is, there was no contestation that Lawrence and Garner committed a crime under Texas law, but rather that the enforcement of that law was not just. Similarly, the ex post facto claim of the Smith plaintiff respondents also did not rely on the "it wasn't me" defense, but rather "it was me, I was already punished for it, you shouldn't punish me again." So this has some kind of similarities to the substantive due process logic of Kennedy's decision. So what I want to end with is a passage from Justice Ginsburg's dissent. And so in this kind of the bold writing down, so first Ginsburg talks about how absolutely this is punishment. This, she gives some reasons why the registry law is punishment. And then she goes on to kind of talk about this other really important question. So what Kennedy said was that this law was not about punishing the plaintiff respondents for potential future acts. It was simply a rational response by the state with a public health interest that responded to previous acts that they had done. And so Ginsburg really strongly disagrees with this contention. But the important part, as Joe Fischel has argued, is that even in the disagreement with the contention, Ginsburg still adopts a particular kind of logic that's also in Kennedy's opinion, which is that someone who is a sex offender must definitionally and ontologically automatically be a risk. Right? Automatically be a risk. And actually, the research does not support this claim at all. So the preponderance of kind of research suggests that sex offenders, people convicted of sex crimes, are among the least likely recidivists of any category of crime in the U.S. criminal system. And yet it is most possible to incarcerate with the least amount of evidence someone who's convicted of a sex crime for life. Throw away the key after they've already kind of served out their sentence. So Ginsburg still acknowledges the possibility that if there had been evidence, right, that the act was like literally written toward the future, that probably would have been all good, right? She might have even agreed with kind of Kennedy's decision. So my point here, I want to close with a point about tolerance. I think that Kennedy's tolerance, right? Kennedy is willing to consider, to speculate, to work actively to frame Lawrence and Garner's alleged sodomy as something that he could be tolerant of. But he does no work of this in terms of sex offenders, no work of any kind. And in fact, the court does not solicit and refuses to acknowledge and does not cite amicus curiae briefs, friend of the court briefs, that, for example, offer these social scientific claims, right, that sex offenders do not provide the same kind of level of future dangerousness that the court simply takes as a given. So I'm not making an equivalence argument. Rather, what I'm suggesting is that the judicial rhetorical frame of liberalized marriage, kind of liberalized contestations of sodomy laws, is underwritten by and underwrites the increasing sophistication of the criminalization of sex offenders as an important part of the kind of out-of-control regime of mass incarceration in the United States. And so if we're going to support marriage, it's at least incumbent upon us to also support the ability of people, no matter what they may have done, to not be incarcerated without just cause. Thank you.